Legal business requirement. Environment. Section 2. The Bill of Exchange. The Bill of Exchange appears in the Middle Ages as a means of transferring funds from one place to another. The change of currency from one place to another was done physically at first, but little by little the change went from being physical to absent, which led to the creation of an notarial document to certify the transfer from one place to the other. This document served as a proof of the assumed transfer obligation. Appearing for the first time in the 16th century, the Bill of Exchange officially became the payment title instead of the exchange certificate. We can define the Bill of Exchange as a security issued by a person called a drawer who orders another called a drawee to pay a certain amount to a third party. It is regulated by the Exchange and Check Law of 1985. The Bill of Exchange must contain the following: the title, the amount, the name of the person who has to pay, called the drawee, the maturity date, the place where the payment is to be made, the name of the person to whom the payment has to be made, or in whose behalf it is to be made, called the payee, and the date and place of issue and the signature of the person who issues the letter, called the drawer. Here's an example. The Bill of Exchange must meet the requirements mentioned to be valid. And now, here's several exceptions. The Bill of Exchange whose maturity date is not expressed shall be considered a sight bill. In the absence of special indications, the place specified next to the name of the drawee shall be considered a place of payment and, at the same time, the domicile of the drawee. The Bill of Exchange that does not indicate the place of issue shall be considered issued at the designated place next to the name of the drawer. The personal elements that may make up the bill are the drawer, who will be the one who issues the Bill of Exchange. The drawee, who must pay the bill, is to whom the payment of the bill must be requested on the due date. The holder person, who has to collect the bill, to whom the payment must be made. Holder and the drawer might be the same person, in which case the Bill of Exchange is called an order bill. The endorser, who transmits the bill in exchange for a compensation. The endorsee, who receives the endorser's letter. The guarantor, the giver of the guarantee, the person who guarantees compliance with the obligations of any parties listed on the bill. And the treasurer is the treasuree is the person who, on behalf of the drawee, makes the payment of the bill. It usually is a banking entity. The bill, with a defect of form, lacks banking validity, but can be used as proof of emission or transmission of the letter. We can find bills of exchange in which some specific information is missing at the time of the issue to be filled in later. This is called a blank bill. The blank bill may be presented to be collected, protested, or etc. once the missing data of the blank bill has been completed and an agreement been made between the author of the letter and the person signing. The majority of the Bill of Exchange can be at a fixed date or within a specific period of time, always in months or days, which is called a time bill. And this points out that in addition to the mandatory clauses, the Bill of Exchange might contain other optional clauses, such as the direct debit of the Bill of Exchange from the Bill of Exchange to a partial acceptance, the designation of indicated payment with interest, return free of charge, exception of the endorser from the guarantee of payment, and acceptance, banning a new endorsement, prohibition of acceptance. The usefulness of the Bill of Exchange is given by its three fundamental characteristics: possibility to demand payment by a judicial process, the solidarity of the legally bound reporting parties, and the abstraction of the debt. Exchange obligations are independent from one another. Article 8 of the Exchange ECL states that when the Bill of Exchange carries signatures, the person who cannot be bound or imaginary persons, false signatures that on any other reason may not oblige the person who have signed the letter, or those on behalf of whom the Bill of Exchange was signed. The obligation of the other signatories shall be valid. Exchange declarations can be made through a representative. Said representative will be mandatory in the event of the one declaring is a legal entity, and those who sign on behalf of another person must be authorized to do so with the power of attorney and must be clearly expressed in the pre-signing. Article 10 points out that in the event that it is signed without the power of attorney, it is bound by the bill and will have the same rights that the representative himself would have had if the Bill of Exchange was paid. Now, in the case of a representative who exceeds their power, the same assumption will be also made without prejudice to the representative's exchange responsibility within the limits of power. The creation of the Bill of Exchange is given at the time that the issuer orders the payee to pay the bill at its due date. Article 1.2 requires the pure and simple mandate to pay a certain sum in pesetas or convertible foreign country admitted to an official quotation. Thus, the law of the quantity indicated and the assurance of the acceptance of payment assumed by the drawer is incorporated in the Bill of Exchange. Article 11, it considers unwritten any clause that claims to accept payment guarantees. Bill of Exchange must include the name of the drawee, the one who has to pay the bill, the name of the person or the orderer to whom the payment of the bill must be made, the signature of the drawer, who is the one who issues it. When the drawer and the drawee are legal entities, it must be state the name of the company. In the event that the drawer or drawee are the same person, the bill is called a letter to oneself or against the drawer themselves. Acceptance of the bill of exchange is normally given at the time when the drawer issues the bill and asks the drawee to accept it, although the acceptance may take place at a later time. The drawee can endorse the bill of exchange, which makes him the endorser, assuming its legal position. The endorser is the one who claims the letter of the endorser. Endorsee is the one who acquires the letter of the endorser. The exchange is reinforced with the statements of acceptance and endorsement that can be found in the bill of exchange, which holds the payment responsible to those who carry them. The acceptance entails the obligation to pay the bill of exchange at its due date by the drawee. Article 49 of the ECL states that the exchange may be direct against the acceptor or its guarantors, or in return against the other party. And in absence of payment, the holder, or even if he or she is the drawer, can press charges against the acceptor or any rights derived from the bill of exchange under this act. The acceptance of the bill is always voluntary, and according to the Article 28 and 29 of the ECL, must meet the following requirements. A, that the acceptance will be stated in the bill of exchange. It will be expressed in the word I accept or any other equivalent and will be signed by the drawee. The signature, when affixed on the top of the front of the bill, is considered as acceptance. B, when the bill is payable within a specified period of sight or when it must be submitted for acceptance within a period fixed by the special stipulation, the acceptance should be dated on the date on which it was submitted, unless the holder requires it to be dated on the day when they submitted the bill of exchange for acceptance. In the absence of the date, the holder, in order to preserve their rights of recourse against the endorsers and the drawer, shall record this omission by raising a protest in due course. The acceptance will be pure and simple, but the drawee may restrict it on the part of the amount. Any other modifications introduced by the acceptance of the text of the bill of exchange will equal to a refusal of acceptance. However, the acceptor will be bound according to the terms of their acceptance. Acceptance will be obligatory in the bills drawn at sight. If the bill submitted for acceptance is not accepted, the drawee is excluded from the exchange obligations. If the refusal of acceptance is made in a reliable manner, it will not affect the obligation assumed by the rest of the signers of the bill. The endorsement of the bill is a declaration in which the holder transmits their right of collection to another person. And Article 16 makes a requirement for the endorsement to be signed by the endorser, usually at the back of the bill, and this shows their consent and presents an obligation to exchange. According to Article 15, any condition in which the endorsement is made subject should be considered unwritten, and partial endorsement is void. The endorsement must be total, pure, and simple. When the appointment of the endorsee is not precise, we find a blank endorsement. In this case, according to Article 17, the holder may fill out the blank endorsement with their own name or that of another person, may further endorse the blank bill, or by so doing designating a specific endorsee, may hand over the letter to a third party without completing the blank endorsement and without endorsing it. The endorsement develops into three basic effects: translational effect, legitimizing effect, and guarantee effect. Another of the exchange declarations is that of the guarantor, by which a person guarantees the obligation of payment of the bill of exchange by the foreign exchange obligor. The guarantor is an accessory which cannot exist without the valid obligation and is independent of the main obligation. The ECL considers the guarantee valid even though the guaranteed obligation is null for any reason other than a defect of formality. When the guarantor, the giver of the guarantee, pays the bill of exchange, he acquires the rights arising from the bill of exchange against the person guaranteed and against those who are responsible for it, the bill of exchange. Article 36 establishes that to be an endorsement, a signature which should be affixed on the face of the bill has to be anyone but the drawee or the drawer. Article 35 states that regarding the date, it may be signed even after the expiration and refusal of the payment of the bill of exchange, provided that the guarantor will not be released from his obligation, his or her. The guarantor responds directly if he endorses the acceptor, and indirectly if he endorses the drawer or endorser. In case of non-payment of the bill, legal action can be taken. To do so, it is enough to say, submit the bill payable within the specified period that the drawee has refused to accept. Submit the bill payable upon seeing that the drawee refuses to pay, and certify the presence and the refusal of the presentation and refusal to pay. The check. The check is a negotiable instrument that contains a payment order for a certain sum of money by a bank in favor of a third party. The check works as a payment instrument. It prevents the handling of cash. It is based on a check contract between the drawer and drawee by which the bank agrees to comply with the drawer's payment order as long as there are funds in his or her account. The check must contain the title of the check expressed by the language used for the writing of that title, the pure and simple order to pay a certain amount in euros or convertible foreign currency admitted to official listings, the name of the person who must pay, called the drawee, which must necessarily be a bank, and the place of payment, of course. There's the date and place of the issuance of the check, and the signature of one who issues the check, called the drawer. Now, in the event that some of the mentioned data is not expressed in the check, in the absence of a special indication, the place specified next to the name of the drawee will be considered the place of payment. When several places are indicated, the check will be payable to the first place mentioned. B, in the absence of these indications or other, the check must be paid at the place where it has been issued. And if the drawee does not reside in the indicated place, it would be paid where the drawee has his or her main residence. A check with no indications of the place of issue will be considered to be issued in the one that appears next to the name of the drawer. The check can be cleared to be paid in favor of a specific person with or without the clause to order nominative check, in favor of a specified person with the clause 2, and to the bearer. According to Article 135, the holder must present the payment within a certain period from the issue of the payments, depending on the following. The check issued and payable in Spain must be submitted for payment within 3 to 15 days. Legal business environment. Mod 2, Part 2, the date and purchase of the issuance of a check, the key signature of the one who is issuing the check, called the drawer. Let us review those first few in case they were missed. The check must contain title, pure and simple order to payment, certain amount, name of person who must pay, called the drawee, and we must necessarily, which must necessarily be a bank, and the place of payment. Okay, now here we go. In some events, some of the mentioned data is not expressed in the absence of special indication. The place certified, yes, we've had this already. In the absence of the check must be paid where it is issued, and a check with no indication the place will be considered to be issued at the place next. Okay, check can be cleared to be paid in favor of a specific person with or without a cause, nominative check, and in favor of the person who's mentioned with the words to and to the bearer. And according to the 135 ESL, the holder must present the payment within a certain period from the date of issue, depending on the following. If it is issued and payable in Spain, it must be within 15 days. The issued and payable in Spain must be submitted within 20 days. If it is issued in 60 days, it was issued outside of Europe. And the previous installments are computed from the date shown on the check as the issue date, not including any non-working days. And if they're an expiration date, it will be understood that the check expires on the first business day following. Now, Articles 143 to 145 provide a series of means so the check is not paid in cash, but by means of accounting credits into their accounts for the same account credit institution or a different one. The cross-check can be general or specific. Yes, I remember these cross-checks. It is general that it does not contain any designation between the two bars, or if it contains the word bank or company or is an equivalent term. It is special if the name of the specific bank is written between the bars. The drawer or the holder of the check may prohibit payment of cash, adding and reverse sides to pay to a bank account or equivalent expression. In this case, the drawee can only pay the check through an entry in his account. The entry is equivalent to a payment. Any erasures of the mention to pay the account are considered as not done. For the transmission of the check, it must be taken into account that depending on how it is issued, it will be transmitted one way or another. When the check is issued to the bearer, it is transmitted by its delivery. When the check is nominative, with or without a clause or to order, it is transmitted through an endorsement. It does not contain a clause. There is no possibility of an endorsement. The endorsement of a check must be total, pure, and simple. If conditions are established, they will be understood as unwritten, and the partial endorsements will be considered void, as well as the endorsement made by the drawee. The promissory note is a legal instrument with a legal regime similar to a bill of exchange. Here we have one example. Sum payment, yes, and it might mention interest rate, and it'll be witness, and so on and so forth. The difference between the two. If the promissory note contains an unconditional promise to pay a certain amount to a specified person, the requirement of a promissory note is that it does not have to follow an official model. Instead of the drawer or drawee, the signer, who is the one issuing the promissory note, and the holder is the one who will be paid, appear. Promissory note must contain the phrase, I will pay. A pure and simple promise to pay a certain amount. The indication of maturity, if it is not expressed, it is understood to be payable on demand. The place of payment, if not indicated, it is understood that the place of payment is the place where the promissory note is issued. The name of the person to whom the payment is to be made, and the date and the place where it is signed, and the signature of the one who is issuing the promissory note. Now we come to mercantile companies. In this section, we will study the mercantile societies in terms of representatives of different legal forms that an entrepreneur or business person can adopt in the marketplace. The objectives of this unit will be to familiarize ourselves with with the advantages and disadvantages of various types of companies to choose the most appropriate one to act in the market, the operation of each mercantile society, the responsibility that each society has, the functioning of social entities related to the mercantile society, the issue and possible modifications, responses and consequences arising from the dissolution of a company. Consumer users are defined as natural or legal entities who act in a field unrelated to a business or professional activity. Consumer is a figure defended legally by the public powers through effective means and procedures. The security, health, and legitimate economic interest must be guaranteed according to Article 51 of the Spanish Constitution. The European law and the Spanish law defend the figure of the consumer and user, since they start from the basis that they act at a disadvantage compared to the businessman because they have less information and knowledge of the product or service. The consumer defense rules, the consolidated text of the general law, contains several rules in relationship to consumers and users regarding the regime of abusive clauses or guarantees of the buyer in case of non-compliance. Some examples are consumer protection against contracts signed outside commercial establishments, regulation of civil liabilities for damages caused by defective products, regulation of package stores, rules concerning the information that the consumer must receive before hiring a product or service. Other rules related to the consumer are given in the contract rules, consumer credits, and the organization of retail trade. Business owners, although the commercial code continues to consider businessmen as merchants, we could define them as natural or legal entities that carry out business activities in the market or goods and services and acquire the ownership or of the rights and obligations of said activities. The legal concept of business owner allows him or her to develop his or her business directly or indirectly through third party or representative. Being classified as a business owner entails being subject to a series of rules that are part of the legal status of companies and of a mercantile company nature in some contracts or partnerships. In order to carry out the business activity, the businessman needs the commercial establishment and the collaboration of people who make commercial contracts. And the entrepreneur, the commercial code defines the figure of an entrepreneur as a trader with legal capacity to engage in trade, which he is usually dedicated to. The commercial code requires this person to be recognized as a trader with the capacity and habitual development of commercial activity, as well as being of legal age and having free access to their assets. Article 3 of the CCO recognizes that there will be a legal presumption of the regular practice of commercial activities from the moment the person intending to carry it out starts to advertise in newspaper posters an establishment aimed at some type of trade. It is not necessary to register in the mercantile registry as an individual entrepreneur. Article 14 enumerates the entities that cannot practice the commercial profession by themselves or on behalf of another, nor have direct administrative or economic involvement in commercial or industrial companies within the districts, provinces, and towns in which they perform their function. Here they are: the magistrates, judges, and officials of the public prosecutor's office in active service. This provision shall not apply to mayors, judges, and municipal prosecutors, or to those who perform judicial or fiscal functions incidentally. Government, economic, or military heads of a district, province, or places, employees involved in the collection or administration of state funds appointed by the government, except for those who administer or collect by entry and their representatives. Exchange agents and trade brokers of any kind, those that by the law or special provisions cannot trade in a given territory. Now we come to the business owner's accounting. The Code of Commerce establishes that every businessman needs to maintain a orderly accounting which is appropriate to the activity of the company and allows a chronological monitoring of all its operations, as well as a periodic preparation of balance sheets and inventories. The law requires the employer to keep a balance sheet and a cash flow. It is compulsory to take these books to the mercantile registry so that before their use, the stamp of the registry is placed on the first page of each one of them. The annual balance sheets and cash flow need to start with a detailed initial balance sheet of the company, and at least a quarter of the balance sheet must be transcribed with amounts and balances. The closing inventory for the year and the annual accounts will also be transcribed. Here is an example. Let's zoom in on this if we can. Oh yeah. Here we have the company name, assets. This will be transcribed here, right? Long-term debts and so on and so forth. And here is a cash flow, I do believe. Oopsie doopsie, this one does not feel happy. There you are, cash flow, right on. We had this in our accounting. Yep. The cash flow is used to record on a daily basis of the operation related to the activity of the company. And Article 29 stipulates that all books and accounting documents must be kept, regardless of the procedure used, in date order, without blank spaces, interpolations, deletions, or erasures. The errors or omissions in the accounting entries need to be corrected immediately after being noticed. Abbreviation of symbols whose meaning is not precise according to law, regulation, or commercial practice of the general application should not be used. At the close of the fiscal year, the employee must prepare the annual accounts of his or her company, which will include a balance sheet, profit and loss statement, account, a statement reflecting changes in the net equity of the year, and a statement of cash flows, and the record. The elements of a balance sheet are the assets, and they're written here. Rights and other resources come economically controlled by the company resulting from past events from which the company is likely to obtain economic benefits in the future. From an economic financial point of view, they represent everything that has value in its own. They indicate whether the financial resources obtained by the company are invested. Now, the liabilities, on the other hand, current obligations arising from the results of past events, those whose extinction is likely to lead to a decrease in the resources that may produce economic benefit. And for these purposes, provisions are understood to be included. Liabilities reflect the financing sources or the origin of the funds that the company uses for a specific time, the acquisition of assets. Now we come to net equity. It constitutes the residual part, the assets of the company once all of its liabilities have been deducted. It includes the contributions made either at the time of their incorporation or subsequent ones by their partners or owners, which are not included in the liabilities, as well as the accumulated result of other variations that affect them. The elements of the profit and loss account and the statement reflected changes in the worth equity of the year are the revenue and expenses. Revenue increases the network during the year, either in the form of revenue or increases the value of the assets, or decreases in liabilities. It's also considered a revenue, provided that they do not come from partners or owners. And expenses decreases in the equity of the year, either in the form of outflows or decreases in the value of the assets, depreciation really, and increase of liabilities, provided that they do not come from partners or owners. The annual accounts must be written clearly and show the true picture of the assets, the financial situation and result of the company in accordance with the legal provisions. The annual accounts must be formulated expressing the value in euros. Trading companies, concept and types. The concept of trading companies is defined by the Civil Code as a contract by which two or more people put in something in common with the aim of sharing among themselves the benefits that come from it. A distinction can be made between trading companies and NGOs, non-governmental organizations, even though the practice is not of great importance. Thus, we understand trading companies as those aimed at obtaining commercial profit. In addition, they need to be registered in the Mercantile Registry and recorded in the public deed. NGOs, on the other hand, are those that do not carry out a business activity. These different kinds of companies that fall within the scope of the trading company are classified according to their responsibility taken by their partners. And based on this criterion, we can distinguish a limited liability company, LLC, companies in which it is the company itself that has to respond before third parties. Partners have a limited liability in the company, and the contribution they make to the company is restricted. Within this group, we would find the private limited companies, PLC, by shares mutual guarantee company, unlimited liability companies. In this type of company, the partners' responsibilities go beyond the main contribution to the company, and indeed the responsibility before third party rests with the partners, who have to respond with their own assets. Within this group, we would find civil societies, business partnerships, and limited partnerships. Trading companies, apart from classifying them based on the responsibility of their partners, can be divided into two groups: partnership groups. The value is placed on the conditions of the partners, partnership, limited partnership, and economic interest association, and the capitalist companies. In these companies, the capital contribution of the partners is given priority over their personal conditions. Limited companies, mutual guaranteed companies. Now we come to partnerships. Well, there's a business partnership. The formation and characteristics of it, it can be considered one of the oldest and simplest of the trading companies. In a company which is a partnership, the partners as a whole identified by the company name and work through a common objective. Business partners have their origin in the old merchant societies of the Middle East. These are companies in which the parents' responsibilities, or partners' responsibilities, are unlimited. So they use their assets to cover the company's debts. Although currently the formation of this type of company has decreased, they are still used to encompass in the legal regime those companies in which the established social type is not clear, or those that do not meet the necessary conditions to be incorporated, such as an SA or private limited company, and still carry out commercial activities. Legal. The characteristics of business partnerships. Well, the partners assume an unlimited joint and subsidiary responsibility for the company's debts. The equity of the company will be the first to be used to pay the debts of the company. In an event that is not used, partners use their own assets. All the partners are considered as a single debtor, and if one of them pays, he or she has the right to claim from the other partners the proportional part of the debt paid. All partners participate in the administration of the company unless otherwise agreed, and the interests of the company or the partnership cannot be passed on to a third party without the other parties giving their consent. Like every trading company, a business partnership needs to be recorded in a public deed and be registered in the Mercantile Registry. The Commercial Code, Article 125, establishes that the deeds of a business partnership need to include the name, surname, and address of the partner, the business name, the name and surname of the partners entrusted with the management of the company, and use of the corporate signature, the capital that each partner contributes in cash, credits, or goods, with an expression of the value given to them or the basis upon which the appraisal is to be made, the company's duration, the amounts that, if applicable, are assigned to each managing partner annually for their own expenses, all other legal agreements and special conditions that the partner wishes to establish may also be recorded in the deed. Now we come to the rights and obligations of this business partner. The first obligation is to provide goods or work. The partners have the duty to act in good faith towards a company, prohibiting competition between partners aimed at obtaining personal benefits through the company. Partners have the right and the obligation, unless otherwise agreed, to participate in the management of the company. Partners have the right to irrevocably elect a chairperson, meaning he or she cannot be dismissed. If in the case of mismanagement, it can be decided to change the chairperson. The partners can ask a judge to dismiss the latter by appointing a co-administrator. The partners have the right of information on the status of the management and accounting of the company. The partners have the right to access the profits of the company and equity resulting from its liquidation. Agreements within partnerships. The agreements within partnerships and transmissions of the social part are always carried out unanimously. We must bear in mind that in this type of company, the partners assume a high risk when having to respond with their personal assets, and that is why making decisions at the management level is done unanimously and taking into account the opinion of each member. Article 222 includes the possibility of the entity of the new partner by succession. In the event of the death of a partner, their heirs may enter as long as it is previously expressed in the partner's agreement. Another decision that requires unanimity is the exclusion of partners. In Article 218, the exclusion of a partner can be requested in the following situations: the use by a partner of a common capital or the corporate signature for undertaking business on their own accounts; interfering in the administrative functions of the company by a partner who does not have to perform them according to the conditions of the partnership contract; if managing partner commits a fraud in the administration or accounting of the company; or for not adding to the common fund the capital stipulated for each partner in the partnership contract, even after having been required to verify it; and if a partner carries out trading operations that are not lawful on his or her own, or when a partner who is obliged to perform in the partnership is absent, even though they have been required to return and fulfill the duties they do not provide a just cause for being temporarily unable to do so, and if one or more of the partners fails to comply with the obligations that were imposed in the partnership contract to begin with. Now we come to the dissolution, liquidation, and termination of the company. Termination of the company must go through various stages: dissolution, liquidation, and final extinction. These causes can lead to the dissolution of the company, can be objective, affecting the society, or subjective, affecting the partner. According to Article 221, the fulfillment of the term established in the company contract or the achievement of the company's objective is one of the causes of dissolution, or the entire loss of the capital is a cause, or the start of a liquidation phase and the company's declared bankruptcy of the company declaring bankruptcy. And when it comes to the subjective clauses, Article 222 includes the following: in the event of the death of one of the partners, if the public deed does not express agreement that the heirs of the deceased partner will become part of the company, then his or her shares will be divided among the surviving members. Whoa! Time. Dementia or other causes that result in the inability of a managing partner to manage their assets, or the opening of a liquidation phase in the administration of any partner. Limited partnerships. The limited partnership is regulated in the commercial code and differs from the business partnership because in addition to the general partners, there are limited partners. The limited partners are characterized by the contribution of capital to company and limited responsibility to it. Unlike with general partners, limited partners only respond with the capital contributed to the company. They lack management capacity based on the liability regime limited to the capital contributed. Public deed of the limited partnership includes the same data as the business partnership and must be registered with the mercantile registry. The names of the limited partners can never be included in the registered names of the limited partnerships. If a limited partner includes their name or consents to their inclusion in the corporate name, he or she will be subject with respect to people alien to the company to the same responsibilities as the manager without acquiring more rights than those corresponding to his or her status as a limited partner. Now, regarding the right of information collected in the business partnerships, in the case of limited partnerships, this right is limited according to Article 150. Limited partners may not examine the status or situation of the company except in the specific periods and under conditions of the founders' agreement. And if the contract does not contain information regarding procedures to check the finance of the company, it will be necessary to give information to the limited partners about the balance sheet of the company at the end of the year, showing them, during a period not shorter than 15 days, the background and precise documents to prove and judge the operations. Capitalist societies. Societies anonyme. Oh, okay. Don't look at that. Illuminati. This type of corporation was born in the modern age in 17th and 18th centuries of so-called colonial companies. Need large capital to start up large maritime and colonial companies. And this need for large capital was solved by dividing capital into small parts called shares. Yeah. The value of the shares was scarce, and together with the limited liability acquired by the partners made this type of company very attractive to small investors. In public limited companies, capital divided into shares is made up of contributions from members who are not personally responsible for social debts. Public limited companies must have a minimum capital of 60,000 euros and are constituted through public deed and registration of the commercial registry. The inscription of the company in the mercantile registry has a constitutive character, and without it, the legal denomination of SA is not acquired. let's get that. Oh yeah, Société Anonyme. This registration must be published in the Official Gazette of the Mercantile Registry. Article 23 establishes the part that is that as a minimum must be included in the articles of incorporation of any of these companies, which is the identity of the partner or partners, the will to constitute a business association with the election of a determined social type, the contribution that each partner makes, or in the case of the anonymous ones, has been obliged to make, and the numbering of shares attributed to the exchange, the company's bylaws, the identity of the person or persons who are originally responsible for the administration and representation of the company. In the case of public limited companies, the deed of incorporation shall express the total or approximate amount of the expenses of corporation, both of which are already paid and those merely provided until the inscription. The bylaws, which are needed to govern the operation of the companies, include the name of the company, the social object, determining the activities that comprise it, the registered office, the share capital, the stocks and the shares in which it is divided, its nominal value and its sequential numbering. And if it is an SA, the bylaws will express the type of shares and series, if they exist, the part of the face value pending payments, as well as the form and maximum time limits within which it needs to be satisfied. And if the shares are represented by means of title, bonds, or book entities, if shares represent them, it must be indicated whether they are nominative or bearer shares, and if issuance of multiple certificates is foreseen. The way or means of organizing the administration of the company, the number of administrators to release, the maximum or minimum number, as well as the term of the office and compensation system, if any. In partnerships limited by shares, the identity of the general partners will also be expressed, and the way of deliberating and adopting agreements of the company's bodies. Shares in the company, the public limited represented part of the capital of the company that, in addition to being the value of stock, the association social participation grants its owners a series of rights. Here are Article 93. Here are the rights of the such persons participating in the distribution of social profits and in the equity resulting from the liquidation, preferential subscription in the issuance of new shares or bonds convertible into shares, attending or voting on general meetings and challenging social agreements, and the rights to information. However, public limited companies may issue non-voting shares for a nominal amount not exceeding half of the paid-in capital stock. Here are the rights of holders of these types of shares. Non-voting shares will be entitled to receive the annual minimal fixed or variable dividend established by the bylaws. Once the minimum dividend has been agreed, the holders of non-voting shares will be entitled to the same dividend corresponding to ordinary shares. When there is revenue, the company is obliged to agree on the distribution of the minimum dividends referred to in the previous paragraph. In the case of non-listed companies, if there is no distributable profits, or if there are not enough, the part of the unpaid premium dividend must be paid within the following 5 years. While the minimum dividend is not satisfied, shares without voting rights shall be entitled to equal conditions as ordinary shares, retaining in any case the economic advantage. Non-voting shares will not be affected by the reduction of the share capital due to losses, regardless of the form in which it was carried out, only when the reduction exceeds the nominal value of the remaining shares. If the result of the reduction in nominal value of the non-voting shares exceeds half of the paid-in capital, that proportion must be restored with the maximum period of 2 years. Otherwise, the company will be dissolved. When by virtue of the reduction of the capital and all the ordinary shares are amortized, the non-voting share shall have this right until their proportion provided by the law is restored using ordinary shares. The non-voting share shall confer on the holder the right to obtain reimbursement of the value paid before any amount is distributed to the remaining partners of the event of liquidation of the company. The right of the preferential subscriptions of the holders of the non-voting shares, as well as the recovery of the right to vote in case of non-payment of the minimum dividend and the non-cumulative nature, therefore, is in the bylaws of the listed companies. Social participation in non-voting shares will be awarded their shareholders with the right to the ordinary shares, except as otherwise provided for in the previous articles. Non-voting shares may not be grouped for the purpose of appointing members of the board or management by the proposal representation system. The nominal value of these shares will not be taken into account for the exercise of that right by the remaining shareholders. The non-voting shares will be subject to the statutory and legal supplementary rules on transfer of preemptive subscription rights. The share capital of the SA is inseparably linked to the shares, since the nominal value of these multiplied by the number of shares constitute the figure of the share capital. The amount of the share capital remains unchanged during the life of the company, unless by agreement of the board it is increased or decreased by the bylaws. Shares have three kinds of value: the nominal value, the value set as part of the share capital; the market value, subject to the laws in the stock market; and the book value, the result of dividing the net worth per book between the number of shares. Understanding the shares as part of the capital company, the contributions that the members can make can be monetary or non-monetary, although always with an economic value and excluding the contribution of work and services. According to Article 59, the creation of the shareholding and the issuance of shares that do not correspond to the equity contribution of the company will be null, and no shares may be created or issued for a figure lower than their nominal value. The financial contributions must be in euros, and the non-monetary contributions must be described with their registration data, if any, the value in euros attributed to them, as well as the numbering of the shares or shares attributed. According to Article 67, in the creation and increase of corporation's capital, non-monetary contribution, regardless of the nature, shall be subject to a report prepared by one of the more independent experts with professional competence appointed by the mercantile register or of the registered address, according to the procedure that was determined by the registration. The report shall contain the description of the contribution with its registry address, if any, and if the valuation of the contribution expressing the criteria used, and if corresponds to the nominal value, and where appropriate, to the share premium issued as a counterpart. The values given to the contribution of the society may not be higher than the assessment made by the experts. Experts will be held liable by the company, shareholders, and creditors for the damages caused by the valuation. Will be exonerated if proof that he or she is being diligent and uses the proper standards. The action demanding this responsibility will be prescribed 4 years from the date of the report. Company shares within the capital of the private limited company is divided must be fully assumed by the partners, and the nominal value of each of them must be paid in full at the moment of granting the incorporation of the company or increase in the share capital. The shares, in addition to being representative as value stocks of the social partnership, can also be represented as book entries, and in both cases will be considered as transferable securities that can be nominative or bearer values. Corporate bodies. The bodies of the corporation are the general body, which is the body that is responsible for the decisions of the company, and the administrators who execute the decisions. And then we come to the general board. The general board meeting within the corporation is the meeting of all the partners to make decisions and discuss the actions of the company. At the meeting, shareholders decide by majority vote on the matters that pertain to the board and to the partners. Included in the dissenters and those who have not participated in the meeting are subject to the resolutions of the general board meeting. Meetings must duly be convened by the administrator and may be ordinary or extraordinary. The ordinary board meeting will necessarily take place within the first 6 months of each year to censure the social management, approve the accounts of the previous year, and to decide on the application of the results. The type of meeting will be valid even if it has been called or held after the deadline. The convening of ordinary board meetings must be done through an announcement in the official gazette of the Mercantile Registry and on the board's website, and in its absence, in one of the newspapers with the largest circulation in the province 1 month in advance. The announcement must include the date of the meeting and the matters to be discussed. The date and time of the second call can also be added if necessary, taking into account that 24 hours must elapse between the two calls. In the case of extraordinary board meetings, administrators may call them whenever they consider them convenient for the company's interest. They must convene it when requested by partners who are holders of at least 5% of the share capital, expressing in the request the matters to be discussed at the meeting. In this case, the meeting must be held within 2 months following the date on which the administrators were requested by a notary to convene it. The administrators will draw up the agenda, including the matters that have been subject of the request. The general meeting of the shareholders will be valued on first call when the shareholders present or represented hold at least 25% of the share capital with voting rights. When the shareholders present, at least 25% of the share capital with voting rights. In the second call, the meeting will be valid regardless of the percentage of capital in attendance, unless the bylaws establish a quorum, which means that the number must necessarily be inferior to what is established or required by law in the first call. The attendance in the third call of shareholders present or represented who hold at least 50% of the subscribed capital with voting rights will be necessary so that the ordinary or extraordinary general meetings can be validly agreed to, and the increase of or reduction of the capital and any other amendments by the bylaws. The issuance of the obligations, the elimination or limitation of rights, and limitation of the right or preferential acquisition of new shares, as well as the transformation, merger, spin-off, or global assignments of assets and liabilities and transfer of domicile to the foreign country. In the second call, the attendance of 25% of said capital will be sufficient. Where there are shareholders representing less than 50% of the subscribed capital with their right to vote, the resolution referred to in its preceding paragraphs may only be validly adopted with the favorable vote of 2/3 of the capital present or represented at the meeting. The bylaws may increase the quorums or majorities provided in the previous section. Limitations on attendance and voting rights. The bylaws may require the possession of a minimum number of shares, regardless of their classes or series, in order to attend the general board meeting without the required number exceeding 1 per 1,000 of the share capital. They may also set in general terms the maximum number of votes that can be cast by the same shareholder or companies belonging to the same group. To fulfill the right to attend the meeting or the right to vote, the grouping of actions shall be lawful. In accordance with the bylaws, the votes of the proposal included in the agenda of any kind of general meeting may be delegated or exercised by the shareholders through postal, electronic, or other means of remote communication, providing that the identity of the subject exercising his or her vote is duly guaranteed. The shareholders who cast their vote remotely must be considered present for the purpose of forming a meeting. Now we come to the administrators of public limited companies. They do not have to be shareholders. These are elected by the general board meeting, and their appointment is freely revocable. The term of office must be fixed in the bylaws of the company and cannot last more than 6 years. Along with the duty of diligent administration, administrators have a duty of loyalty and secrecy. They are prohibited from using the name of the company and invoking the status of administrator, as well as taking advantage of business opportunities, competition, and intervening in agreements or decisions regarding operations in which there are conflicts of interest. Responsibilities of the administrator are included in Articles 225 and 236. Here they are. The directors will be held liable by the company, shareholders, and social creditors for the damage caused by acts or omissions contrary to the law, bylaws, or for those carried out in breach of the duties related to the position. The person acting as the chairperson of the company will personally be held liable by the company, shareholders, and creditors for the damage caused by acts contrary to the law or by the bylaws, or for those carried out in breach of the duties that this law imposes on those who formerly hold this position. All members of the administrative body that made the act shall respond jointly and severally and adopt the detrimental resolution. Those who prove that have not intervened in their adoption, and those that prove that having not intervened in the adoption or execution, they did not know of their existence, or knowing it did everything possible to avoid the damage, or at least expressly oppose it. Under no circumstances shall the fact that an act of detrimental resolution has been adopted, authorized, or ratified by the general meeting be waived. The position of administrator is free of charge unless the bylaws establish otherwise. And in the event there has been a remittance, that this should be specified by the bylaws. When it is participation in the profits, can only be withdrawn from the liquid profits, and after the attention of the legal reserve and the bylaws is covered, and after the 4% dividend has been paid out to the shareholders, or the highest rate that the bylaws have established. Remuneration is given shares or rights over them, and must be expressly provided for in the bylaws, and its application will require an agreement of the general board. The agreement will express the number of shares to be given, the price of exercising options right, the share value taken as a reference, and the term of this remuneration. In societies where the administration is entrusted to 2 or more people, a board of directors must be established. The board of directors will consist of a minimum of 3 people. The bylaws will set the maximum minimum number of members of the board of directors, and the general board will determine the specific number of its components. Resolutions of the board of directors shall be adopted by absolute majority for the directors attending the meeting. The discussions and agreements of the board of directors will be kept in a book of minutes, which will be signed by the presidency and the secretary. The company annual statements. The company directs are obliged to prepare within a maximum period of 3 months from the close of the fiscal year the annual statements, the management report, and the proposals for the application of the result, as well as, where applicable, the accounts and the consolidated management reports. The annual accounts and the management reports must be signed by all the administrators. If the signatures of any of them is missing, it will be indicated in each of the documents in which it's missing, with an express indication of the cause. The content of the annual accounts of the public limited meeting is regulated by Article 254. The annual statements will include the balance sheet, the profit and loss sheet, statement reflecting the changes in net equity, and statement of the cash flows and reports. And these documents, which are a unit, must be clearly written and show the true state of the assets, the financial situation, and the results of the company in accordance with the law and with the provisions of the Commercial Code. And the structure and content of the documents that made up the annual accounts will be adjusted to the regulatory approved models. Article 257 formulates the abbreviated profit and loss accounts for 2 consecutive years when they meet at the closing date of each of them, at least 2 of the following circumstances: that the total assets do not exceed 11,400,000 euros, that the net amount of its annual turnover does not exceed 22,800,000 euros, that the average number of workers employed during the year does not exceed 250. The company will lose the power to formulate abbreviated profit and loss statements if they fail to meet for 2 consecutive years 2 of the circumstances referred to in a previous chapter. The annual accounts, where appropriate, the management report must be reviewed by an auditor. The person who must perform the audit of the accounts will be appointed by the general meeting before the end of the year, and to be audited for the initial period of time, which cannot be less than 3 years or more than 9, starting from the date on which the first fiscal year to begin auditing begins. And the activity will be carried out without prejudice to the provision of the regulation governing the activity of audit of accounts regarding the possibility of extension. The bylaws. The bylaws that regulate the operation of the capital companies shall include the name of the company purpose, determining the activities that comprise it, the registered office, the share capital, the shares in which it is divided, its nominal value, and its correlated numbering. The bylaws must explain the share classes and the types of any, the part of the nominal value pending disbursement, as well as the form and the maximum term in which it needs to be satisfied, and if the shares are represented by stock values or book entries. If they are represented by means of stock values, it must be indicated if they are nominative, or bearer shares. And if the issuance of multiple securities is foreseen. How to organize the administration of the company, the number of administrators, or at least the maximum and minimum numbers, as well as the term of position and remuneration system, if any, the way that the collegiate bodies of the society have to deliberate and make a deal. Companies can decide to modify their bylaws. The modifications imply a change in the way of ruling the company up to that moment, which is why a report written by the administrators is required to justify the modifications proposed. Modification to the bylaws will be the responsibility of the General Board. The amendment agreement must be recorded in the public deed and registered in the Mercantile Register. Modification to the bylaws may affect the obligations of the partners who consent for its approval will be required. It may also directly or indirectly affect the rights of classes of shares. In both cases, it must be approved in a general board meeting. Even so, the modifications for the most relevant bylaws are those that correspond to the increase or reduction of capital. Equity increase. The increase of the capital may be made by creating new shares and issuing new shares, or raising the nominal value of existing shares. In both cases, the capital increase may be carried out by adding new cash or non-monetary contributions to the corporate assets, including providing credits or loans charged to benefits or reserves that were already included in the last approved cash flow. The General Board, with the requirements established for the modification of bylaws, may delegate to the administrators the ability to indicate the date on which the already adopted agreement to increase the share capital must be carried out in the agreed figure and a set of conditions of the same in everything not foreseen as a result in the resolution of the meeting. The time frame for this exercise to this delegated power may not exceed 1 year, except in the case of conversion of obligations into shares. Now, the power to agree on the don't forget what you're saying here. You're saying that you may delegate to the administrators the power to agree on one or several times the increase of the capital stock up to a certain amount, and in the amount that they decide without prior consultation with the General Board. These increases cannot be greater than half of the capital of the company at the time of the authorization, and must be made through cash contributions within the maximum period of 5 years from the date of the General Board resolution. Equity reduction. In the case of capital reduction, this can be done by reducing the nominal value of the shares by amortizing or grouping the necessary number of them. There are several reasons why a company decides to reduce its social capital. The reasons may respond to the need to adjust some patrimony inferior to the social capital that affects the appearance of solvency of the company, and that does not correspond to reality. It may also be the case that the company is overcapitalized and has more capital than necessary to carry out its activities. Article 318 indicates that the reduction of the capital must be agreed by the General Board with the requirements of the modification of the bylaws. The resolution of the meeting will express at least the amount of capital reduced and the purpose of the reduction, the procedure by which the company has to carry it out, and the execution period and the amount to be paid, if applicable, to the partners. In the reduction of capital, the partners can use their right of opposition. The decrease in capital can negatively affect creditors because they can receive a lower value for their shares than they contributed at the time in case the company decides to return the shares to the partners. If there is opposition, the company must guarantee repayment. Even so, Article 335 poses the following cases in which the rights cannot be exceeded. When the reduction of capital has the sole purpose of restoring the balance between capital and the diminished net worth of the company as a result of losses. When the reduction is for the purpose of formation or increase of the legal reserve. When the reduction is payable by benefits-free reserves or through amortization of shares acquired by the company for free. In this case, the nominal value of the redeemed shares or the reduction of its nominal value shall be allocated to a reserve from which will only be possible to have the same requirements for the reduction of the capital. Private limited companies concept. In a private limited company, a PLC, the capital, which will be divided into company shares, will be integrated by the contribution of all the partners who will not personally be liable for the social debts. In SA, unlike a private limited company, the capital is divided into holdings that do not undergo free transfer, as in the case of shares. We could consider that PLCs mix the characteristics of capitalist societies in terms of the limited responsibility of the shareholders' equity and the characteristics of personal partnerships by incorporating regulatory elements of personal relationships among the more limited number of partners. Formation. The formation of a PLC, the minimum capital is, €3,000. As in an SA, the contributions to the partners must be economically valuable, but unlike these, in the case of monetary contributions, no expert report is necessary for the goods contributed. The company must register a public deed with the Mercantile Registry, detailing what each partner contributes and the percentage of social capital that corresponds to it. Another difference with the SA companies is that the registration can be done remotely in the bodies. Well, as in the public limited company, the bodies that make up the limited partnership are the general meeting and the administrators. There is also a basic difference in the regulation of limited companies compared to corporations. The general meeting of the PLC has the power to give instructions to the administrative body. According to this article, 161, except for otherwise provided by the law, bylaws, the general meeting of the private limited company may issue instructions to the administrative body or submit an authorization request for the adoption of or decision of the agreement of certain management matters. As for the calls of the general meeting, the same principles and obligations are those the public limited company apply. In the decision making in PLC, it is determined. We think that it's determined anyway. Let's get up there for a wee bit. By the following votes for general decisions or agreements: half plus one vote validly cast are needed, provided they represent 1/3 of the total votes. For capital increases right, so that's called a quorum, I think. Anyway, for capital increases or reductions or any other modification by law, half plus one vote of the total are needed. The authorization to the administrators to engage in the competition, 2/3 of the total vote. For the suppression or limitation of the rights of preference of the capital increase, 2/3 of the vote. For the transfer, merger, spin-off, global assignment of assets and liabilities, and transfer of the registered office abroad, 2/3 of the vote. And for the exclusion of partners, 2/3 of the vote. The administration of limited partnerships can be done through a single administrator, several administrators acting jointly, or through the board of directors. In the board of directors, the minimum and maximum number of members must be set by the general meeting or in the bylaws. The charges in the company are indefinite unless otherwise specified in the bylaws. Now, according to Article 210, the ways to organize the administration in the limited companies are that the administration of the company must be entrusted to a single administrator or several who act jointly or to a board of directors. That in the PLCs, the bylaws may establish different ways of organizing the administration by attributing to the board of directors the option to opt alternatively for any of them without the need of bylaw amendments. And also, any agreement that alters the way of organizing the administration of the company, whether or not it modifies the bylaws, will be recorded in public deed and will be registered with the Mercantile Registry. In PLCs, if there are more than 2 joint administrators, the power of representation shall be exercised jointly by at least 2 of them in the matter determined by the bylaws. Coming again to bylaws. In private limited companies, the administrators cannot amend the bylaws in situations of capital increase. The partners are the ones that prefer the acquire new shares. This right, unlike in other corporations, is not transferable to any third party. This falls on behalf of the people who, according to the GRLSC or the bylaws of the company, in their absence, can freely acquire shares. In the case of capital reductions, according to that Article 3 to 31, the partners to whom all or part of the value of their contributions have been reimbursed shall be jointly and severally liable to each other and to the company for the payment of the social debts contracted prior to the date on which the reduction was effective against the third parties. The liability of each member shall be limited to the amount received as restitution of the social contributions. The partnership or liability shall lapse after 5 years from the date on which the reduction was effected against third parties. The inscription in the Mercantile Registry of the execution of the reduction agreement should include the identity of the person to whom all or part of the social contributions have been restored, or where appropriate, the declaration of the administrative body of the reservation referred to the following articles has been constituted. 332 article includes a solidary execution of the partners when the reduction is agreed by means of a restitution of all or part of the value of the social contributions. A reserve will be set up against the benefits of free reserves for an amount equal to that received by the partners in a concept of restitution of the social contributions. Shares. The social partnership in the private limited company are proportional, indivisible, and cumulative parts of the share capital. Each social participation confers on its legitimate holder the status of a member and attributes the right recognized by the law and in the bylaws. The social participation may not be represented by book entries or be called shares and in no case be considered as securities. The general shares, as well as the shares of the public limited company, grant several rights to the partners, included in Article 93. Participation in the distribution of social profits and the inequity resulting from the liquidation, preferential assumptions in the creation of new participations, attending and voting at general meetings and challenging social agreements, right to information. The shares grant and the same rights to the partner, but different types of, it can be created in the bylaws. Unlike the shares of the SA, these shares can be given plural votes to involve a change in ratio between the votes and the nominal value of the social participation. Private limited companies may increase non-voting shareholders for a nominal amount not exceeding half the capital. The transmission of shares as well as the ownership of each one of them must be included in the book of records. This can be consulted by the partners and will be in the hands of the administration body. The transfer of shares must be recorded in the public document, and unlike shares in public limited companies, unless otherwise stated in the bylaws, the voluntary transfer will be free through inter vivos acts between the partners in favor of the spouse, ascendant, or the descendant of the shareholder. Partners or in favor of companies belonging to the same group. Okay. The rules that govern voluntary inter vivos transmissions are included in Article 107 and are the following. That the partners that intend to transfer his or her participation or participations must notify the administrators in writing stating the number and characteristic of the shares he intends to convey. They identify to the purchaser and price and other conditions of the transfer. The transfer will be subject to the consent of the company, which will be expressed by resolutions in the general board meeting after including the matter on the day's agenda adopted by the ordinary majority established by law. The company may only refuse the consent if it communicates to the transferor through notarial channels the identity of one or more partners or third parties that acquire all the shares. No communication will be necessary to the transferor if this person attended the general board meeting where given agreements were adopted. Partners attending the general meeting will have preference for the acquisition. If there are several concurrent partners interested in acquiring the shares, it will be distributed among them all in proportion to their participation in the capital. And when it is not possible to communicate the identity of one or more partners or third-party purchasers of the totality of the shares, the general meeting may agree that the company itself acquires the shares that no member or third party accepted by the board wishes to acquire, pursuant to what is established at Article 140. The price of participation, the form of payment, and the other conditions of the transfer transaction will be those agreed and communicated to the company by the transferring partner. If the payment of a part or all of the price is postponed in the transmission project for the acquisition of shares, it will be prerequisite that a credit institution guarantee the payments of the deferred price. In case in which the proposed transfer is carried out as a form of paid transaction, other than purchase or free of charge, the acquisition price shall be fixed by mutual agreement of the parties, and if not, to the fair value of the shares on the day that the company was informed of the intention to transfer. The fair value will be understood as determined by the auditors of the accounts, differed from the auditors of the company appointed for the purpose of administration of the company. In the case of contributions to the limited partnership, the real value of the shares will be understood as resulting from the report prepared by the independent expert appointed by the commercial registrar. The public document of transfer must be granted within 1 month. The communication by the company of the identity of the purchaser or purchasers. The shareholder may transfer the shares and the conditions communicated to the company within 3 months have elapsed from the date he or she gave notice of the intention of transmitting without the company having communicated the identity of the purchaser or purchasers. Articles 109 and 110 also include the transmission of mortis causa shares and coerced shares. Regulations for the compulsory transfer of social participation. The seizure of social participation in any enforcement procedure must be notified immediately by the company or by the judge or administrative authority that has decreed, stating the identity of the seizure as well as the shares seized. The company will proceed to the annotation of the embargo in the register of partners, sending a copy of the notification received to all members immediately. Once the action has been held, or in the case of any other form of compulsory alienation provided for by the law, prior to the award, the approval of the auction, and the adjudication of the seized social holdings will be suspended. The judge or the administrative authorities will send the company's literal testimony of the auction record or the award agreement, and if applicable, the award requested by the creditor. The company will transfer a copy of the said testimony to all partners with a maximum of 5 days from the receipt thereof. The auction of the award to the creditor will be the final 1 month after the receipt of the company of the testimony referred to in the previous section. As long as they do not become final, the partners, and failing that, and only in the event that the bylaws established in their favor the right of preferential acquisition, the company may be subrogated in place of auctioneer, and where appropriate, the creditor, through the express acceptance of all the conditions of the auction and the full consignment of the amount of the auction, or where appropriate, of the award to the creditor, or of all the expenses incurred. If several partners exercise the subrogation, these shares will be distributed among all in the proportion of their respective corporate shares. Now we come to the regulations of transmission mortis causes. Number 1, the acquisition of any social partnership by inheritance given to the heir or legatee, the status of the partner. Hence the word mortis. Notwithstanding at all the provision of the previous section, the bylaws may establish in favor of the surviving members, and failing that, in favor of the company, a right to acquire the shares of the deceased partner, appreciated at fair value, so that they have the day of the death of the partner, whose price will be paid in cash. The valuation will be governed by the provisions of this law, but for cases of separation of partners and the right acquisition must be exercised with a maximum period of 3 months from the communication to the company of the hereditary acquisition. Now we come to sole proprietorship society. Sole proprietorship can be originated, created by a single partner that responds to the debts before third parties with its patrimony and not with the entire patrimony of the sole partner. It can also be a supervening company in the event that the shares or social participations in their entirety come from a single partner. The sole proprietorship, must be registered in the commercial registry through a public deed, leaving a record of the identity of the sole shareholder. The company must record that it is a sole proprietorship through the company's own documentation, such as invoices mailed, orders for suppliers, invoices, or announcements that by legal or statutory provision must be published. And in the event that after 6 months the sole proprietorship nature of the company is not recorded in the commercial register, the sole partner might become liable personally without limit, jointly and severally, for the social debts generated during the time that the company carried out its activity on the sole proprietorship. Now, in this type of company, despite the fact that there is only one partner, the principles of making agreements through a general meeting and generating corresponding minutes must be followed. So in addition, all contracts must be included in the record book. And according to Article 16, the contracts concluded between the sole shareholder and the company must be in writing or in the documentary form required by law in accordance with its type, and will be transcribed into a registry book of the company and must be legalized in accordance with the provisions of the minutes book of the society. And in the annual report, specific and individual references will be made to these contracts indicating the nature and conditions. And in the case of bankruptcy of the sole proprietorship or of the company, those contracts, including in the previous section, have not been transcribed into the register book and are not referenced in the annual record or have been referenced in the annual report, shall not be bound by law. For a period of 2 years from the date of the conclusion of the contracts referred to in the first paragraph, the sole shareholder shall be liable to the company for the advantage that is directly or indirectly obtained to the detriment of the latter as a result of said contracts. Now we come to dissolution and liquidation of capital companies. The established Articles 360 to 364 are the reasons and causes for which capital companies can be dissolved, and within these causes, the only ones that act immediately are those that are fully fledged. So, dissolution of a right, due to the expiration of the terms established by the bylaws, unless it has been previously expressed extended and the extension into the mercantile registered for 1 year from the adoption of the agreement to reduce the share capital below the legal minimum as a result of compliance with the law, if the transformation or dissolution of the company has not been registered in the mercantile register, or the increase of capital stock of the up to the amount equal to or greater than the legal amount minimum. The opening of the liquidation phase in bankruptcy will result in the dissolution of the company as a matter of law. Now we come to the causes of dissolution. Causes for dissolution. For cessation of the activities that constitute a corporate purpose in particular, it will be understood that the cessation occurred after a period of inactivity of more than 1 year, and by the conclusion of that company that constitutes its objective because of the manifest impossibility of achieving a social purpose due to the paralysis of the social entities in such a way that their operation is impossible. For the losses that reduce the network to the amount less than half of the share capital, unless it is increased or reduced sufficiently, or whenever it is not appropriate to request a declaration of insolvency, and or due to the reduction of the share capital below the legal minimum when it is not in compliance with the law, or because the nominal value of the non-voting value stocks or of the non-voting shares exceeds half of the paid-in capital stock and the proportion was not restored within 2 years, and or for any other cause established by the bylaws. The partnership limited by the shares shall also be dissolved by death, cessation, or inability to or opening of the liquidation phase in the administration of the collective partners, unless within 6 months and by modification of the bylaws a collective partner is incorporated or the transformation of the society into another social type is agreed. Now, the dissolution of the company must be registered with the mercantile registry, and the registration of the dissolution will be sent automatically, remotely, or without any additional cost to the official gazette of the mercantile register for its publication. The dissolution of the company opens the liquidation period. During this time, the administrators will resign their office or will lose the power of representation. In the event that their collaboration is required, they should lend their assistance to the settlement operations. And in Article 376 stipulates that unless otherwise provided by the bylaws, or in case of appointment of liquidators by the General Board of Shareholders that agrees to the dissolution of the company, those who were administrators at the time of dissolution will be converted into liquidators. And in those in which the dissolution was the result of an opening of the liquidation phase of the company in bankruptcy procedures, the liquidators will not be appointed. Once liquidation operations have been completed, the liquidators will submit for final approval the final balance sheet of the General Board, which is a full report on said operations and the project of division among the partners as a result of the resulting asset. The approval agreement can be refuted by the partners who have not voted in favor of it, responding 2 months from the date of adoption. The liquidators will submit for approval a final balance sheet to the general board, as mentioned before, full report on said operations and a project division among the partners as resulting. The approval agreement can be refuted by the partners who have not voted in favor of it within 2 months of the date of adoption. The liquidators in the mercantile registry will grant a public deed of extension to the company that will contain the following. The deadline of the rebuttal of the final balance approval agreement has elapsed without any refute, or it has been resolved, that the creditors have been paid or their loans have all been allocated, that the settlement fee has been paid to the members or the amount has been consigned. The final public deed of liquidation and the relationship of the partners will be included in the public deed, stating their identity and the value of the settlement quota that would have been correspondent to each. Now we come to other companies. Kinds of company. Okay, and we come to the cooperatives. Cooperatives are regulated by the cooperative law and by the law of the autonomous community in which they belong. The law defines cooperatives as the partnership made up of people who join in an association of free accession and the voluntary resignation to carry out resignation in there. I don't think it means resignation. It means they're resigned to doing so or determined to do so. Anyway, to carry out business activities aimed at satisfying their needs and economic and social aspirations. Aspirations is a good word. This type of partnership has its democratic structure and functioning in accordance with the principles formulated by the International Cooperative Alliance. The cooperative formation is through a public deed and must be registered in the Register of Cooperative Societies, which grants them a legal status. There's really two kinds, first level and second. The first level, cooperatives of associated work, cooperatives of consumers and users, housing cooperatives, agri-food cooperatives, cooperatives of community and land service, or cooperatives of the sea. That's interesting. Cooperatives of transport, insurance cooperatives. Oh, okay. Wow, there's more. Health cooperatives, cooperatives of education, and credit cooperatives. Wow. One of the differences between the types of cooperatives is that the first level cooperatives must be constituted with a minimum of 3 members, unless the law of the territory establishes other minimums, which second degree cooperatives must be constituted by a minimum of 2 members. Okay. Cooperatives are formed by the General Assembly. Let's see that we didn't miss anything there. I'm just going to come back to that. This is 54. First level, yeah, first level is marked and given. There was no switch to second level as such. Okay, cooperatives are formed by the General Assembly, composed of the partners that deliberate and adopt the agreements, the governing council that manages and represents the cooperative, the intervention that is responsible for the censorship of accounts. In addition, the fourth body, called the Resource Committee, could be included in the statutes, which would be responsible for challenging the decisions of the governing council. One of the main characteristics of the cooperative is the obligation to establish a mandatory reserve fund, and an education and promotion fund. These funds respond to the main purpose of helping common needs, since 20% of the surpluses have to be allocated to the reserve fund and 5% to the education and promotion fund. The obligatory reserve fund is intended for the consolidation, development, and guarantee of the cooperative and is not distributable among the members. Now, according to Article 56, the Education and Promotion Fund, which will be allocated in application of the basic guidelines established by the bylaws and the general board meeting to activities that fulfill any of the following purposes: training and education of partners and workers in cooperative principles and values, or in the specific manners of the corporation, corporate and working activities and other cooperative activities, the promotion of cooperativism and inter-cooperative relations, the cultural, professional, and welfare promotion of the local environment or the community in general, as well as the improvement of the quality of life and community development and environmental protection actions. Mutual guarantee companies. Mutual guarantee companies were created to help small and medium-sized companies to access financing that is appropriate for their possibilities. These companies with scarce social capital suffer limitations to access the capital market, which reduces their capacity for expansion and growth. So these MGCs, as they're called, grant guarantees, SMEs, access to the small small and medium-sized enterprises? I don't know. Access to the bank. Now, it facilitates access to the privileged financing sources and it allows companies to obtain better loans in the market. It also provides entrepreneurs with the advice and information services of a financial institution that suits them according to their needs. And it is exclusively a company, and it is an exclusive company purpose that allows the employee to benefit from the trust of the entity that grants the loan or the credit. And in this type of company, the partners do not answer to social debts. They are considered a financial entity, and at least small and medium-sized companies must integrate 4/5 of their partners. The minimum social capital of the reciprocal guaranteed companies cannot be less than 10 million euros, and the computable capital cannot be less than 15 million euros. Okay, that's not what I thought. Especially in view of the other one was like 3,000 euros. Anyway, not to worry. Professional associations, here we go, are those corporate purposes in the joint exercise of the professional activities, understanding as the professional activities that which require official university qualifications or professional qualifications in the registration of the corresponding professional association. Professional associations can adopt any form provided by the law, civil societies, limited companies, limited company, cooperative, etc. Yeah, and the partners must answer to social debt according to the form adopted. Venture capital companies. Venture capital companies are entities created to help companies that carry out their activities in high-risk markets, not well-known or established. They can be public authorities that help local companies injecting initial capital in order to encourage the start of their activity. Venture capital companies are made up by companies and their funds, and the corporate purposes of these is the temporary investment in the capital of non-financial corporations, which are not quoted, with the idea of helping these companies in the initial moment of the activity. Once these companies are established, the venture capital will liquidate the investment, selling their shares or participation.